The U.S. Department of Justice is facing the risk of losing control over one of the most dangerous case files in modern political history. At the federal court for the Southern District of New York, a rare legal move has just been triggered. Two members of the U.S. Congress, Ro Khanna, a Democrat from California, and Thomas Massie, a conservative Republican Party congressman from Kentucky, jointly filed a request with the court. They are asking the judge to appoint a special master, an independent overseer, to take control of reviewing and releasing the Epstein files from the hands of the U.S. Department of Justice. This is not a routine technical procedure. It is a direct legal escalation. Once a special master is appointed, control of the files no longer belongs to the Department of Justice, an agency now under suspicion by both Congress and the public of deliberately delaying and concealing information. That is the key point. Once a special master is in place, the Department of Justice no longer gets to decide which documents are released, which are withheld, or how long the review process drags on. Everything unfolds under direct federal court supervision, and that is precisely what makes the request from Ro Khanna and Thomas Massie so sensitive. They are effectively telling the court, we no longer trust the Department of Justice to enforce the law on its own in the Epstein case. The authority to act lies entirely with the federal judge in the Southern District of New York. The Department of Justice can object. It can submit memoranda. It can argue that it is working diligently, that it has mobilized hundreds of lawyers and agents. But the final decision rests with the court. If the judge says appoint a special master, the Department of Justice must hand over the files. In the U.S. justice system, this is real power, not media power, not political power, but the power to compel the executive branch to comply with the law. The question now is whether the judge will approve the request. And here, the factors are stacking up in a way that is unfavorable for the Department of Justice. First, this is a rare bipartisan request. Ro Khanna is a progressive Democrat. Thomas Massie is a Republican Party lawmaker who frequently votes against his own party's leadership. They share no political interests, no joint electoral incentives, and do not belong to the same camp in major political battles. Their joint signature on a legal request to the court carries weight that unilateral actions simply do not. Second, the Department of Justice is trapped in a contradiction of its own making. In court filings, it has insisted that it mobilized massive resources to review the Epstein files. Hundreds of lawyers from the U.S. Attorney's Office for the Southern District of New York, along with FBI agents and personnel from DOJ headquarters. It claims the task is enormous and complex, requiring time, but the reality tells a different story. As of now, the DOJ confirmed that it has released approximately 12,285 documents to the public, totaling about 125,575 pages from the Epstein-Maxwell files. That figure represents less than 1% of the total materials the DOJ may be required to disclose under the Epstein Files Transparency Act, despite the statutory deadline of December 19th, 2025. A figure so small it is almost meaningless when measured against the legal obligations the department itself has pledged to meet. In legal terms, this is no longer an issue of administrative delay. It is a sign of serious non-compliance. That is why the Department of Justice's argument against appointing a special master backfires. If it is truly overwhelmed, why oppose the court appointing an independent overseer to accelerate the process? If it is truly working at full capacity, why is the outcome virtually non-existent? Judges in the Southern District of New York are known for having little patience for this kind of delay, and this is one of the busiest and toughest federal courts in the U.S., regularly handling financial crimes, fraud, terrorism, and organized crime cases, allowing an executive agency to drag out a nationally significant case indefinitely is difficult to justify. If the judge decides to appoint a special master, the case will enter an entirely new phase. The special master could be authorized to use government lawyers, or even enlist major private law firms in Manhattan, home to dozens of the world's leading firms. With that level of resources, reviewing millions of documents in a short time frame is not unrealistic. This would also expose another core claim made by the Department of Justice, that the task exceeds normal capacity. Many lawyers who have handled massive financial prosecutions say that with modern document review technology and a lean, specialized legal team, document volumes far larger than the Epstein files can be processed in weeks, not months or years. In other words, the Department of Justice's justification for delay does not convince legal professionals. However, even if the court issues an order, a thorny question remains. Will the Department of Justice comply? In recent years, there have been troubling precedents of federal agencies failing to fully obey court orders, forcing the judiciary to initiate contempt proceedings. If that scenario repeats itself in the Epstein case, the U.S. would witness a direct confrontation between the executive and judicial branches, a confrontation not merely about a set of documents, but about a fundamental principle. No one is above the law. What political pressure is steadily increasing. Donald Trump has publicly promised to bring transparency to the Epstein files. The Republican Party has repeatedly declared support for transparency, but words and actions are drifting further apart. When the files remain sealed and progress is nearly frozen, those commitments ring hollow, and at the center of all these disputes are the victims, those who were abused, silenced, and forgotten for years. According to the lawmakers, the request to appoint a special master is not meant to target any individual. It is meant to ensure that the truth is brought to light, with victims' identities protected as required by law, while crimes are not concealed. This is where all political analysis must return. The Epstein case is not just about power, money, or conspiracy. It is a test of morality and the rule of law. The gap between real-world capability and the results produced by the Department of Justice has eroded the agency's credibility in this case. Notably, bipartisan cooperation in the Epstein case goes beyond the push for a special master. Congress is also turning its attention to other key figures who could help piece together the financial and power structures behind Epstein. One of the most prominent names is Les Wexner, the billionaire who was a major patron and maintained an unusually close relationship with Epstein for years. Lawmakers argue that without clarifying Wexner's role and that of those who managed Epstein's assets, any document release will remain superficial and fail to reach the core of the network. In addition, Epstein's fund managers, accountants, and lawyers are also on the list of individuals to be subpoenaed. These are the people who understand where the money came from, where it went, and how Epstein was able to sustain such a sophisticated operation for so long without being stopped. Clarifying these links is not only about assigning individual responsibility, but about exposing a sophisticated protection network in which money, connections, and power intertwine to neutralize the law over a long period of time. And it is precisely here that the Epstein case moves far beyond the bounds of a single criminal prosecution. It becomes a major stress test for the political and legal system of the U.S. This is no longer a question about Epstein's past, but a direct confrontation between transparency and power, between the obligation to disclose the truth and the instinct of those in power to protect themselves. Is the final, and most important question still hangs unresolved. Does the law have the strength to force the government to reveal the full truth, or will power once again prevail through silence?